and moving forward to the next session. Discover how ideas transform into tangible advancements, navigate the complexities of sharing technologies for collective progress. Please allow me to introduce our moderator, Professor Dr. Heinz Goddar, partner Boehmert Boehmert. Professor Heinz Goddar, a distinguished German patent attorney and European patent and trademark attorney, has a physics PhD. He is an honorary professor at the University of Bremen, contributing his expertise in intellectual property law globally. Next, I'd like to welcome Dr. Amaresh Panda, Head-TTO of KIIT TTO. Dr. Amaresh Panda, a senior intellectual property professional, contributes a robust background in technology transfer, integrating legal acumen with strategic thinking. I'd also like to welcome Ms. Priyanka Gupta, Associate Partner of IP Commercialization Transaction, IPR, LexOrbis. Ms. Priyanka Gupta, an Associate Partner at LexOrbis, specializes in IP due diligence, technology commercialization and licensing, and IP portfolio management. I'd also like to welcome Ms. Suchi Rai, Partner Designate S&A Law Offices. Ms. Suchi Rai, a patent agent with over 13 years of experience, excels in patents and designs, prosecution, filing, and enforcement with a focus on protecting IP in India. And last but not the least, Mr. Shivakumar R., the Head IPR and Tech Transfer Center's Cellular and Molecular Platforms, or CCAM. Mr. Shivakumar R., an intellectual property attorney with over 16 years of experience, shares insight into patent drafting, prosecution, and managing IP portfolios in life sciences.
Yeah, sorry. I came a little bit late. First of all, I would like to ask to accept my apologies. I was in the embassy of a European Union country here. We talked about our famous or infamous draft regulation for standard essential patents. We talked about this yesterday, and it was an interesting discussion because also countries outside of the European Union, of course, wish now and better should take, well, not influence, but give comments to this pending legislation. As you know, in the European Union, we have two mechanisms to issue and later on enforce laws. The one is directives. Directives are long-term things. This is when the European Union Commission, after the normal consultation process, decision process, including the so-called European Parliament, they give instructions. Directives are to the governments of the European Union. And then they have to implement this into their national laws. And that takes in total sometimes 5 years, 6 years, 7 years, nothing so urgent. The regulation becomes immediate law, applicable directly in the member countries, not the few ones, but except Britain, everybody is still there more or less, and who was originally there. This becomes law, and since this regulation is now in a consultation process, where everybody, the interested circles, inside the European Union, as well as worldwide, are invited to give comments on that to the Commission, and that is a certain Directorate General here, DG GROW it is called. It is headed by a German, Kerstin Jorna, and the commissioner responsible for this, Monsieur Breton, a French commissioner, will go out of office, as people say, end of this year, and he wishes to leave the regulation in a finished form as law, as his legacy in the system. That means, all of a sudden, end of this year, you will have, if you wish to import your phones, your computers, your battery technology devices, your AI systems, whatever, into the European Union, you will be confronted with a new conflict-solving mechanism outside of the courts. This is a system which has the declared aim of getting all standard essential patent disputes out of the civil courts. It will be not private, but a special institution which will come under the leadership of the European Union Intellectual Property Office in Alicante. Why? Because the EPO, which is now European Patent Office, so-called one in Munich, which is presently granting, if you wish so at least as the applicant, unitary patents, which cover the whole European Union essentially, they are not an EU institution. So the Commission wishes to have an agency under them. and thereby under the ruling of the European Union Court of Justice and Government, if you wish, to handle all these questions, because they cannot influence the EPO. Influence, yeah, they can say, better you do this or that, but they cannot instruct them. But in Alicante is a European Union Intellectual Property Office, which until now gives only European Union-wide trademarks and designs and administers them, but they will get a patent competence center. We spoke about this, and this is why it is so important that countries like India, like mainland China, they do it anyway, and many other countries, that you take your view and bring it to the Commission, that it is considered in the rest of this year in the legislative process. This is why I was a little bit late. I spoke about this upon invitation by Ms. Louise Boyson, who is here in the audience, was here, will come later on today. She came back with me here. She gave me the opportunity to talk with the Department of Telecommunication here, and this took a little bit longer. When you go to Central Delhi, it is not difficult in the early morning, but when you come back this time of the day, it takes a while. So sorry that we could not have our consultation process. But we did a very intensive preparatory meeting, 22nd of December, or around that, before Christmas at least, amongst most of the panelists here, and we know what we wish to talk about here today. We talk about technology transfer, its improvement, etc. We talked about this over the last few days. Your whole conference here of GIPC is dedicated to that goal, to use patents as vehicles. Now, patents, and this we will not touch so much upon here today, patents as vehicles where you can offer in a safe manner to mankind, if you wish so, what you have innovated in the garden of innovation, protected by the intellectual property rights, notably patents, protecting you against unauthorized use of your technology. But there is the door, Article 7 TRIPS, in the fence where you give others access to your innovation. So the more patents you file, the more declarations you give that you wish to share your innovation with mankind. Patents are instruments to exclude others. We know this. But we talked about this. That's all what intellectual property rights are about. But they are also something where you can give allowance to use them. And this is the purpose, to make it in a safe manner for the innovator possible, whether it is a startup, whether it is an individual, whether it is a big company, that you can talk with others and negotiate whether they wish to share against maybe fair, reasonable, and non-discriminatory contributions which they give to your investment cost, your profit expectation, etc., to share your innovation. So patents is practically dealt with in other contexts. What do we do, however, in a situation like today, and you can read in the newspapers that we heard this yesterday in some sessions here, particularly in the very last one, where I was only for a certain time, I had other obligations still thereafter, where we hear that many, many innovations are not protected by patenting, which means disclosure, necessarily. This is why the Venetians in the 14th century, at least as Europe is concerned, maybe in India even earlier, in mainland China maybe even earlier, in Russia maybe 10 years, 20, 30, 100 years ago, I don't know what, but I'm joking. No, the Venetians invented the patent system that people don't keep anymore secret their innovations, rather publish them with the help of the government, to give them a certificate that for a certain period of time, now where everybody knows the innovation, is now entitled only after a certain while to break this monopoly situation and to use the innovation. That was the deal. But more and more you see, and I would like to remind you of the COVID times, which are just hopefully over everywhere, where even big pharmaceutical companies, like my dear German biotech in my home university, Mainz, located, where they said, if we give you a license under our patents, like Moderna, the same thing, they gave it to Pfizer at the end of the day, CureVac in Tübingen, where they say it is not enough, even if you are allowed to use our patent, how to make a certain mRNA-based, technology-based vaccine, You cannot make it really. You need to know more. And what is more is our secret. We don't tell you. We use the classical way which everybody used worldwide before the Venetians, namely not to tell anybody what they have invented so that nobody could copy them. How can you copy something which you don't know? And there was yesterday this question in the last session. I liked this a lot. I had no time then later on to comment on this myself. What do we do in this case? You decide, and you see this in this example which I just gave you, you have now a trade secret protected technology. Practically, you are prevented nowadays from sharing this knowledge with others. If you talk with somebody, you will have a non-disclosure agreement. It is a sheet of paper. Some parties have signed it, and whether it is kept in force, whether it is followed, depends on the trustworthiness of the people signing it. At the end of the day, nothing. And there is my personal idea, and I know that WIPO under Darren Tang, he likes this idea a lot. We talked about this in Singapore, in Geneva, he's talking with other people. This is the idea, should we not have a trusted depository where trade secrets, data, whatever we cannot patent or don't wish to patent, can be deposited in a secret manner, maybe blockchain secured. We talked about this a few days before. Somehow you have a second documentation. You ask your inventor in your company, an individual inventor split his brain already into two parts. One part is some information you wish to transform into a patent. Where is then the, I would say, trusted depository, which is the patent? Nobody is allowed, because of authority of the government, guaranteeing that the patent has to be followed. You can now talk with others what should the conditions be to transfer the technology, to give the knowledge to other parties against reasonable remuneration, etc. But you don't have this for trade secrets. So what about having a place, probably not a physical place, maybe only somewhere in the cloud, where you have secured by some mechanisms like keyword blockchain, you put those parts of your technology which are not in the patent, which other people, however, at least those who wish to use the technology in the best possible manner, beyond what is written in the patent, can get the information they need, the trade secret protected one, and then they can have the complete technology available, and you can transfer everything. Then nobody will say, well, tell an Indian company, for example, it doesn't help if you get a license, whether it is a voluntary one or compulsory one, under a patent, because you need additional knowledge, and without that, you cannot make the vaccine, for example. And I think this idea should be followed up. And some country has to be the pioneer for this. And I think India, where these discussions in CII, in other circles here, in NASDAQ, they go all around, and people are talking about this. I know this from the own group for whom I work a lot, this is the Tata group. Should we not have such a depository? Somebody has to take the lead. And that would be something which is similar to what we have in Budapest since I think 40 years about, where WIPO has a trusted depository for biological material, viruses, bacteria, whatever you need to conduct a certain patent teaching which says you take bacteria A, put it into a piece of iron, and tomorrow human insulin comes out. This is a little bit, of course, an abbreviated story. But there is the depository. There you can negotiate a license also to get access to this material. And we would have then a two-part world of vehicles for doing technology transfer. Not the patented one. This is well dealt with nearly everywhere. Well, not so well, but we are all trying to improve it. But that we have a second world available where we can put knowledge that is not patentable, or for certain decisions of the innovators not patented, where you can give them, even if you wish so, also fair, reasonable, non-discriminatory additional licenses. So if somebody wishes to have the benefit at least of doing the best mode of US law requested this for a long time until AIA, as you know, to describe this even in a patent. Nobody does this anymore nowadays, where you can get this additional knowledge. So we will talk here, and the panelists will now talk in the order of those who are here. At least we will just decide this. We were in that discussion. They had reminded me when I was sitting in the car from the embassy of Denmark here, I should please come at 12 o'clock, but I was still struck somewhere, I don't know, near the parliament or wherever here. It took a while. So that we talk about this non-patented ways or non-patent related ways to transfer technology, otherwise unprotected technology. What is available? What do we need in terms of NDA? What do we need to secure objectively such additional know-how? We don't know. And I would now like to invite the panelists. Whom did you decide who should speak first now? You do this. Thank you so much.
Hello, everyone. Good afternoon. And to start with how best we can protect the trade secret, first and foremost is the non-disclosure agreement, wherein it is important to mention that clause wherein the employees of the company or any research institutes are bound to disclose the know-how and confidential information not only during the employment and also after they are terminated. So this is one clause which should be present in the non-disclosure agreement. Thereafter, the know-how and any confidential information should be very well protected during the course of the employment. Every information that is informed to the employee should be marked as confidential and trade secret. Thereafter, the secret information is to be shared only with the concerned team, wherein the research team is working on particular project. Thereafter, there should be technical demonstrations wherein the complete technology is not exposed and only the technical demonstration is given to the interested parties, wherein they can identify the research in action and invest accordingly. Then there is a possibility of a trusted depository, wherein they can choose a research institute or any reputable law firm wherein they can store the information, and the information with respect to their know-how in the research technology will be available to the concerned persons only. And the various ways of technology transfer includes licensing, wherein one party is transferring rights to the other party with help of the licensing agreements. Then there is technology acquisition, wherein the one company is acquiring rights right away in the invention through purchase agreements. Then there are exhibition, wherein the companies can do the demonstration of the technology. And one option is open sourcing, wherein the know-how of the company is exposed to open sourcing and crowdsourcing. When we talk about patents, it is easier to transfer the rights in the patents. But when talking about trade secrets, it is essential to secure the information about trade secrets within the company during the course of research. Thank you.
Thank you so much. We keep this in mind. This was non-disclosure agreement, what we have to do there to keep secret, etc. Before I give the word to this next speaker, it is Mr. Shivakumar. And I would like to remind you of one conflict which you might also have in India constitution or also in other countries. We have this at least in Europe and particularly in Germany. Our constitution, German constitution, imposed to Germany by our allies, not our allies, the allies who reformed Germany after the Second World War. They gave us our constitution. This is not a German invention. This has some influence from the United States, from France, from Britain, not from the Soviet Union at that time, because they had their separate country in Germany, which was only since 1990 reunited with the rest of it. But the Constitution says, in principle, research, the freedom of research and teaching, and that includes that the results of publicly funded research of all our universities must be made available to mankind. They are for publication. That means a university is not entitled legally to keep anything sacred. Now you have these increasing alliances, of course, between universities, other public research institutions, Max Planck Association, Fraunhofer Association, you know all the names, and there comes invention out. In this invention, there are two inventors. The one comes from a funding big industry, let's say from Bayer or Boehringer Ingelheim in pharma, or it comes from Siemens or Bosch or whatsoever in car industry. One inventor, that company has only one interest, to keep this invention at least secret as long as they do not yet file a patent application. The university, in principle, must make sure that the results are as quickly as possible published and used for teaching, because the major role of the universities is teaching, educating, sharing knowledge. What to do? And our master agreements I talked about, of the German Federal Ministry for Economy, which are the model agreements for industry, German industry university cooperation in Germany, they take care of this. It is very, very complicated, I can only say. We will talk later on about this dilemma between the mission, I would say, of a university and a private company, which has only one mission, to make profits. Otherwise, the shareholders will say, oh, you have to do whatever is necessary to make the profit as high as possible. Now it is your turn.
Thank you, Dr. Heinz. Good afternoon, everyone. So, in the context of technology transfer, one can look at protected IP, which is not the focus of today's discussion. The other point is about unprotected IP. So, when we say protected IP, everyone thinks about patents, trademarks, design applications, copyright registrations, and so on. As a technology transfer office, how do we protect ideas or inventions which are not published, which are not protected, say a know-how, say a trade secret, or anything for that matter, say for example, an invention for which the publication is already made. You see a point of, if there is a grace period available for such inventions, still be able to protect inventions or protect by way of IP. So that is one point that one can look at. But the critical point is about the trade secret, for example. So trade secret, how do you ensure that there is a trade secret? How do you ensure that the transfer of knowledge, transfer of technology happens, which is bound by a trade secret? By way of agreements, by way of, the confidentiality maintained within the close-knit group of individuals to ensure that the trade secret is maintained, and hence you have checks and balances like password protected, accessibility to individuals within the organization and within and to the industry to whom the technology is transferred. Just to give an example, where, say for example, I have an invention where I produce a metabolite. I filed a patent application for it. I covered the method, and in one of the steps I have mentioned that the temperature can be maintained between 20 to 30 degrees Celsius for 20 minutes. But as a trade secret, I don't want to disclose that the temperature can be maintained between 20 to 30, but what you do in the process is you maintain it at 20 for 2 minutes, maintain it at 25 for 3 minutes, then come back to 22, then go back to 28. All these are trade secrets. You don't have to necessarily disclose in the patent application, or if you haven't disclosed in the patent application, then that calls for a trade secret. This is something that is not there in the public. So you speak to the industry partner, you say that, hey, there is a method, but you know how the method is performed. You can take the specification, which is already published by way of patent application, perform the method, but you will not be able to get the results like the way we are obtaining, because while we have mentioned in one of the steps as 20 to 30, we do it at 20, 22, 25, 28 at different durations, in different time durations, and that's a trade secret, for which you will execute a license agreement with the industry partner on patent application, but there is a hidden trade secret. And that trade secret is to be maintained within the close knit of individuals between the licensor and the licensee. So that's one. How do you ensure that the trade secret is transferred as a technology? Second, know-how. Know-how means everyone knows about it. It's a knowledge that one can actually ensure to deliver, smoothly and efficiently. So one can also think about that know-how is something that is already there in the public domain, need not be always. Know-how can be information within the organization which is commonly known, generally known to be performed by individuals skilled in that field. But how efficiently and how smoothly is a question. So that is where know-how, even if it is not protected, again, there is a trade secret that kicks in. How do you protect know-how? How do you ensure that the technology is transferred? How do you ensure that the know-how is transferred? How do you actually create visibility for such aspects, be it a trade secret or be it a know-how? Know-how, for example, say, I'm taking another example, Dr. Heinz, a pesticidal composition. Globally, there are, it is a global concern that in the agricultural field, farmers are struggling to fight with the pests that infest their crops. So I have a solution, but it is a know-how. It is not protected by way of any IP. How do I ensure that the knowledge is transferred? Ensure that the visibility is created by just disclosing in the social media platforms or in the conference or wherever you go, you publish in your website, but disclose information only to the extent of the surface level information. Hey, I have a pesticidal composition that can combat a number of pests, and this is a global concern, and here is a solution. You stop it there without disclosing anything more about the pesticidal composition, what it contains, the ingredients, the concentration of the components. Even if you may disclose the components of the pesticidal composition, you need not disclose about the concentrations, the ratios of the concentrations of the components that would play a critical role in combating the pests. So these are the aspects that you need to probe as a technology transfer professional when someone comes to you about transferring a technology, which is a know-how, which is a trade secret. So, yeah. Thank you, Dr. Heinz. That's from my side.
Yeah, and I would like to add the following. I'm also a material scientist. I'm a polymer man. When I talk about these examples you are telling us, compositions and how to make them, the know-how, the additional one, my informatic people always say, don't forget data to train AI systems, because they are empty, these AI systems. If you don't have, for the self-learning process, you have not data available. Where do we do them today? Would they not also be a nice thing to be deposited in such a trade secret protected or trusted depository? We don't know. But this is only an additional comment in between. Maybe one comment also. In German employee invention law, which for good reasons I mentioned many times already here in this conference, if the employer takes from a private company, and the university still special rules, we don't talk about this here now, if the employer takes the invention from the inventor against reasonable remuneration, the employer has a choice to either patent the invention, if it is a patentable invention, or to keep it secret. But if he keeps it secret, he has to accept general patentability and to pay remuneration as if it would be patented, so that he cannot lean back and say, oh, I keep this thing secret, then I don't have to pay my employee. No way. Trade secrets are valued in a similar manner. Actually, the license and energy-based remuneration is then only about 50% of what you would give in case of patenting, but it is a special remuneration. Trade secrets are subject to inventor law-based valuation of innovations. That's just in between. Now we come to the next contribution.
Hi, good afternoon all. Yeah, thank you, Professor. It's my advice to all the audience and all the organizations. We should not practice this trade secret technology transfer in India, because as of now in India, in aspects of Western country, it's good because you have a very structured law for trade secret. You can protect it, but in India, we don't have also the protection in that level for patent as well, because the bar of infringement for patent in India, it's very difficult to a plaintiff, to prove it in comparison to US and Europe and Canada as well. Yeah, there are some fields where we can practice the trade secret. First of all, we should know in Indian ecosystem, the most of the technology transfer where it's moving on from the small scale, innovator to the industry. We have three type of innovator. That's individual one, then startup companies, and small scale industry. Okay, and most of the funds, the individual innovators or academia, they're getting from either government fund or venture centers or angel inventors. Okay, if you are getting funds from government during 6 months or 1 year evaluation, you have to share your information to them, and it's completely non-protected. Okay, so it's not advisable to go for trade secret for the technology transfer. Second, VC or angel investor, they can protect your information. As I mentioned, we don't have any structural law for trade secret in India because there are so many employees from both the sides will be open up to that technology. Anybody can, anytime, disclose that thing to any third party. Third thing is that, yes, you can, but for some contributory invention, as Shiv rightly mentioned, let's say you have a pharmaceutical product or any product, and you have a process come product invention, I can say it. Let's say your one team is doing the process and another team is doing the product, and they are not working in the same place, but you are controlling all the things, A or B. In that time, you as a head of the institution, you can think for that. But the team A doesn't know about the team B work, and team B doesn't know what team A is doing now. And you have all the information, you go to an organization to transfer your know-how, transfer your research, or transfer your technology to that company, but you are hiding the process part. That can be, somehow you are protected from your end as per the per se of trade secret. That can you do. And one more thing, that's biologist part, that NBA approval. We all know if you are inventing some bacteria, you will go and file a NBA approval. You have to, okay? If you don't file any patent application, but you go, have your NBA approval, and in that NBA approval, it's completely protected with government, and there is a code for that. And for that, you can go for a trade secret-based technology transfer. Because nobody can get that information, because you have only the code, nobody can get all the access about that. So these are the way, we can think about that, but as you know, because if I'm, talking about that Bayh-Dole Act in 1980 in US, how 50 years before, 45 years before they have started the process of technology transfer. However, you can't get that so huge product into the market or impact in the society or the economy of that country or of that world. That's trade secret based one. No. Let's say pacemaker, Google, and then your, GPS, that's COVID vaccine. They all are, developed in the process of technology transfer. Developed by a university, by academia, transferred to a company. They all are developed in that process. But they all are patent protected. I couldn't find yet in a very big product available in the market, which is, coming around on the trade secret path, Because technology transfer is nothing but a creative and collaborative endeavor. That's translate knowledge and research from licensor to licensee. And also, if in India, let's say a startup company or academia, they don't have that much of establishment to draft a licensing agreement, to draft a proper NDA, they don't have. They have to take a help of a law firm. The third party also be a part of that. Because you don't have that much of strong. If you are a company A, let's say when I was in a big pharma company like Glenmark and Sun Pharma, they are also transferred their technology to big pharma company. They are completed the phase 1, phase 2, and transferred the molecule to big US company or Europe company. They can do. They have a strong legal team. But what about the startup company? What about the individual innovator? Because they have to go to a law firm. Now, how could you believe? Because that law firm also working for 5 people. Yeah, you have an NDA with them. As per the signing agreement, they should not disclose your information to anyone. But as I mentioned, in India, if somebody does this type of activities, it's very, very difficult to prove that in the court of law, and you are going for an infringement or for a damage. You can ask them. So it's in my point of view, because till now it's it's very difficult because I'm heading a techno transfer office here in KIIT University. I have a jurisdiction in north and eastern part of India. It's very difficult to take our industry for that patent protected technology because in India the system is not that developed. Our industry is looking forward to technology from a university. It's very, very difficult. Though you have a granted patent, and if you are telling them I have a technology or invention or innovation which is under trade secret, believing that they couldn't believe you after 1 year or 2 years, somebody from your team or maybe you as a startup company may disclose the information to any third party. So there are so many drawbacks. To practice on that process, as I mentioned, you can go for a contributory invention, you can go for any NBA approval process, any bacteria, microorganism you have created and protected under NBA, you can think for that. Few area you can target it, but in a general practice, it's very advisable, go and adopt the IP protected pathways. In India basically, but in Western country, you can think for that because they have a very established law. You can get your damages, if you prove that there is something, mishappening done by any party in the court of law, you can have it. Thank you.
Yeah, maybe I can briefly add this before I ask Priyanka for giving her comments. We had the similar situation, like you apparently have it still in India, in Germany, until a few years ago. In the European Union, and thereby also in Germany, we introduced a more effective trade secret protection, not only by unfair competition law, that if you steal something, you are not entitled to use it. Only a few years ago, I think 7, 8 years or something, we didn't have this before. And probably this step has to be done in it would be recommendable from my viewpoint if India does a similar thing. And what you said about the data, for example, for pharmaceutical admission procedures, this comes very close to what I would like to propose to generalize into this trusted depository for any kind of what you do in the patent. And I can tell you one thing, there's a phone company, they don't make only phones, they make mainly not phones, but network structures. They are in Shenzhen, it is not ZTE. They request from their inventors, meanwhile, already 2 kinds of documentation when they file a notification of inventorship to the employer. So one is what should be put into a patent, which should be the basis for the usual patent application. So whatever you, in other words, wish to publish, because that means publishing if it is not just a military invention or something like this. But the second documentation, what additional know-how do you know? In order to have an objective documentation of your know-how which you have available and which could then later on be used into any mission with a code accessible by which right you could, by a right which you would give to somebody to access this depository where the know-how is, etc. So you file the patent application and you deposit the additional know-how somewhere. The big question is, and by the way, unsolved nowadays, is such a patent, which also to the patent scholars here, is such a patent where the patentee, the patent applicant, knows already at the date of first filing that certain additional know-how is necessary to enable you to exercise the patent. Isn't that patent invalid because it has lacking of enabling disclosure? I don't know. Maybe we need to complement that by some know-how which you can access under certain legal conditions, etc. Because otherwise you have series of patents. Vaccines are one of the examples which are simply invalid. You can ignore them. Yeah?
So I think most of it is covered through contracts, the ways of disclosing trade secrets, whether we should have trade secrets or not. But in my limited experience of technology transfer, I have not seen any technology transfer happening without the transfer of know-how. If someone says that I'm only doing technology transfer basis my patent right, or basis my trademark right, I do not know how that technology transfer is going to be viable. The most critical point, which I think Amaresh also mentioned, the individual inventors. When they develop something which is, as per them, is unique, is solving a challenge, they are so excited to take it to the industry. A very key concept, nowadays people have started talking about it. In the West, I'm sure it is well versed, and Dr. Goddar, you can mention technology readiness level. Now, you have filed a patent, very good. As Indians, we have started to file patents. As Indians, we've started to recognize the importance of patent right. But what does the industry require is something called as technology readiness level. And is your patent document enough to transfer your technology at that particular level that the industry can accept? And can that only be achieved with a patent document? No. You need to disclose the know-how. You need to disclose the process, the test results, and after negotiating and after looking at those agreements, I have seen inventors toiling day and night to achieve that TRL level. And sometimes overdoing and oversharing information so that industry accepts their patented invention, and which we also call as proof of concept. Going on site, I was working with a pesticides company, because you mentioned pesticides. And I was working with a pesticides company, and they had a group of small inventors which was not backed by any institute. These inventors had a good granted Indian patent, as well as a patent in some of the Asian Pacific countries. And they wanted to transfer this technology to a pesticide company based in Mumbai. And they were on site for approximately 1.5 years to make sure that their patented technology is accepted by this particular company, and they get the returns in terms of either royalty, one-time payments. And in the process, they helped the company improvise their process. And I'm not sure did they get their contributory invention rights or not. So what happens is, because of the lack of the entire trade secret protection, the inventors overshare. They want this technology to be implemented, so they customize the proof of concept as per the environment of the industry. They lead to further invention which remains unprotected, because they're most of the time not aware that they have helped the industry with something called as a process improvement thereof. So it is very essential, and because I'm a part of a law firm now, very essential to help them educate about their rights while drafting these licensing agreements. And these licensing agreements are not boilerplates. They're not boilerplates. So if somebody would say that, okay, you can download it from the internet and it's standard intellectual property clause, it's a standard confidentiality agreement clause, no, it is not. You have to make the inventor and the university or any incubation office who's supporting them, make them the importance of realizing the know-how, trade secret, test results, material transfer, and you have to categorically call it out. What is getting transferred? What is it, the extent which is getting transferred, the extent of involvement of the inventor or the team, research team supporting the inventors. Inventors don't work alone. They have a research teams which is working with them day and night. And categorically call it out. And you may be pushed back by the industry, because of their huge legal teams. You may be pushed back, you may be intimidated, but it is very important to protect their interests, because what they are developing can be the future tomorrow. So a lot of institutes in India are working, like all the technology transfer offices. They are doing commendable job in letting the inventors know that don't get overexcited that industry is, recognizing your technology. You have to step by step understand what you are disclosing, how you are disclosing, and what extent you are disclosing. So I think in India, agreements are the only way you can protect. And to the extent you have to educate inventors how much of trade secret you can disclose. One more scenario I would like to bring about is POV, plant varieties. Plant varieties are very well protected in India. There is a complete law and system, and you keep talking about, Dr. Goddar, you were talking about this trusted source where you can protect information, all of that you're talking. Now, how do you protect plant varieties which are already protected? There's a basmati rice which is protected by an institute. Basmati rice variety. It is, if copied by several other farmers or several other small companies, how can you go and infringe? Claim for infringement? It is very difficult, and the trade secret leakage there is again very, very, very easy. So all in all, enforcement of trade secrets, protection of trade secrets, even if your intellectual property is protected, is difficult in India, very difficult. And what we advise to people who have actually innovated and created is go with slowly, gradually. You don't want to miss the train also, but you don't want to overshare as well. And contracts are the only way to protect your information which you have created. Those are my 2 cents.
Yeah, I think when I hear these very interesting comments, we had the pleasure a few weeks ago for nearly a week to work together for DRDO, a certain seminar also, Priyanka and I. And I think we all are of the opinion that we need a second source of secure storage of know-how where we can give the access right. We need a market for the access right to know-how. For that, you need first a depository for the know-how, that it is identified, that the rules are clear under which you can access it, and you can have really a part of a second licensing market for that, and maybe complementary to the patent one. And what we also need as patent attorneys, the drafters here, we need to learn how to draft know-how documentations, which is a different thing, where you have not these hesitations not to tell too much, but just enough to enable somebody to use the patent, that it is valid, but you can really write down whatever you think could be the source for some additional, let's say, skill which a licensee could get. And you can sell this. You can give a license under this, a second know-how license. One way, I think, in India is a special problem still that has to do with your patent law. In software-related inventions, you have that problem not so much. You can only patent CRI, that means computer-related inventions, which is similar to our European computer-implemented inventions. That's fine. We cannot protect software and algorithm as such. We can't do this in Europe either, but their copyright steps in because that is copyright protected. But look at pharmaceutical inventions. Slight improvements, let's say second and third applications of a certain medicament, which is protected by a patent to to cure heart attacks. And now you find out it is good against cancer or whatever. In other countries, like in Germany, like in Japan, like United States, wherever, you can patent this secondary invention. For good reasons, I believe India has when the fathers of the present regulation came, where they said, this is evergreening, you cannot get a patent on this new application, etc. That's fine. But it also prevents a whole group of inventions where you read every day, oh, it has now been found out, look at Novo Nordisk, my dear client in Denmark, I come just from the Danish embassy, where they make tons of money in the meantime of using a diabetes medicament in order to slim down people, much more convenient than not to eat anymore. Yeah, this is a wonderful patentable invention. In India, I believe it would not be patentable at all to find out the secondary use and then to patent it. So also these things, in a country where you cannot patent certain elements, it would be good to have a depository for this know-how where you can again give a license under in a similar manner as with a patented technology. Just an example which came during these interesting contributions here into my mind. I think we are simply running out of time. What I do is I will now start from the left side again, with Priyanka in this case. Everybody on the panel should give a final comment to the one question: should we have a trusted depository of what manner soever where you can give controlled and not necessarily free, but reasonably controlled also by a contribution to what the inventor has done? Should we have a trusted depository for know-how or not? And if we should have one, we can only, at the end of the day, stand up and pray and appeal to the government of India, would you please take the initiative and support it at WIPO to create such a thing? Now, first, should we have one or not?
In my view, it's still premature to have such a trusted repository. That's my view, because it does carry the whole risk of leakage, which is real, specifically for inventions which take much, much time to develop. And yes, there is an entire concept of open innovation, but that also comes with entire concept of open source compliances. So you cannot just copy anything for free. There is a right to left and right to copy. So in my view, trusted sources are still a premature thing at this stage.
Yeah, actually, Professor, I have one comment regarding your second use in India, you are talking about Swiss claim. If I'm not wrong, in Europe, you have a second use of a, FPI, then you can go and file a patent application. You have easily get a, extended patent for that. But in India, the main obstacle is that section 3D. On that basis, it's very difficult to get a second use of any establishment, API or medicament to have it. But it's not, okay, you are not getting that patent, the threshold is too high. You have to prove the clinical efficacy with yes. And the term is not yet defined anywhere in India. You can get that judgment from the court of law. So there's some difficulties there, but it's not that you are not getting it. Yeah. And about that, depository part, I agree with her, as a context of India. It's, I can say, to maintain all the data and to securely maintain, it's difficult. And nowadays, I can also say, in US, the website and everything of Pentagon also attacked by third party, it's not also protected. So you are putting all the information, all the invention in one system, and somebody can, China is master on that, if I am not wrong. They can also all the try to, enter into the system. So how can you protect the innovator rights? So that's a little bit difficult to do. If you have that type of 3-tier protection, then you can think for that. I hope in India it's not the right time to do so. In future, it may be. If we can take all the concerns of the innovators and how we can protect by 3-layer all the information, we are going to save in the depository, then that will be the right time to start the process.
Yeah, thank you so much. I go to you.
I think, in my opinion, and for the comfort of companies, I would suggest that any of the research institutes or some reputable law firm can be considered as a trusted depository for know-how and trade secrets, which is accessible to companies nearby, and that information will be protected by the law firm and research institute, and will be shared only on required basis on certain terms and conditions. I think that will be the best possible situation currently, and for trusted depository as such required, maybe in future we can have trusted security depository for same. Yes.
So, see, as a country, we have we are at an advanced level, and we have advanced to a stage where I think things can be taken forward. In all fields, we have seen in last 2 decades as to how we have advanced. We have achieved what was not possible. So, in my opinion, with all the concerns that that was mentioned by Dr. Amaresh and Priyanka, if we are able to take care of those concerns, I think trusted depository is required, is my opinion. One last point, we are all talking about unprotected IP and protected IP in the context of technology transfer. While having this trusted depository will help us in protecting the technology which is not protected by way of IP, I think that will be one of the best possible solutions in future if we can have the trusted depository. Also, having said that, there are very many instances where IP is essential and people come to us as technology transfer professionals, as IP professionals. Our endeavor is to guide them to protect it by way of IP. However, having said that, there could be certain instances where people are not comfortable in disclosing all the information in the patent application. They don't want to reveal the secret. People are able to maintain the confidentiality. Then, you go with the confidence that, you can do something by way of protection, by way of, executing an agreement on trade secret. Just cited some examples during my earlier discussion. So maybe those could be the points that one could consider. So, thank you.
Yeah, thanks a lot. We are practically already concluding now, but I would like to leave you with one question. We all are in favor, I think, of a trusted depository. We all think that certain mechanisms will have to be followed. Thank you that I learned now. I thought second medical use is not patentable at all in India, but I didn't know. Thank you. Yeah, I've learned something. Also in SOFA. Yeah, I know. Thank you. And also, one thing. Do we not need also, if this additional know-how now taken out of the unprotected area, the wide field, into a protected area, namely by this trusted depository, access of which you can license out? Or don't we also need to include it then into a compulsory license course? What is a compulsory license under the patent verse if you cannot use that patent without the additional know-how? Do we not need to include into the general rules, TRIPS controlled, patent laws have this, when you can grant a compulsory license or a governmental authority or authorization is given to use a certain patent in the interest of India, or in my case of my own country or whatever, should we not, and need we not even then, to include also the access, the additional right to look into that know-how? Possibly, yes. It is interesting. I talked about this a lot with Corey Salzberg of Novartis, global patent litigator head, and he likes in principle, if I understood him correctly, that it is good that we have such an additional depository for know-how. Even Big Pharma is very much in favor of this, I think, to have a more reliable play field to play on. But when I said, but please, then you need also to put this under compulsory licensing regulations. Well, being from Novartis, I could understand that he was a little bit reluctant to accept this idea. But this is just anecdotal, and I thank the panelists, the audience for having been so patient, and thank you so much. Let's look forward to what this discussion will in future bring. Protection of unprotected secret know-how of whatever kind, and do we need a new mechanism? And I would really hope that India, who has such a strong voice in WIPO, in the concert of nations, that India, for example, taking so much care also of small and medium-sized enterprises. Maybe in India even more than in Germany. 80% of our GDP comes from companies with less than 500 employees. These are small and medium-sized, not Siemens, not probably the same thing, yeah? So and that would be a good idea, I think, for you. Thanks a lot, and let's discuss.
Yeah, you know, unprotected, your, technology transfer for unprotected, IP. In India, all the protected IP also is, 80% is coming under unprotected IP. It's, as I mentioned, it's very difficult, to proving all the time infringement, and also to get the information from the market. If somebody is, using your technology in the market, since from trademark, design patent and patent, because structure is not established yet, and it's a 140 billion, country. It's not like US, Germany, you have very small populated country. It's very easy to get that info. But in India, it's some person earlier mentioning about that Sarojini market in Delhi. You will go there, you can get many more trademark, infringement there.
We are just being reminded. I got already a reminder 5 minutes, about 10 minutes ago. Sorry about that. We are delaying everything. And thank you, everybody, for having been here, participated, and for your patience. Thanks.
Closing this session with the sincerest thanks, I'd like to welcome Mr. Vinayak Katkalembekar to give out the gifts. Group photo, sir.